You know, usually when we talk about getting like a medical diagnosis, there's this expectation of precision,
Oh, absolutely. Oh,
right?
yeah.
It's almost like engineering. You
Hmm.
break your arm, they take an x-ray, and it shows that jagged white line. And the doctor just points at the screen and says, there it is. That's the problem. And here's exactly how we fix it.
Right, because, I mean, biology doesn't change based on where you're standing.
Right.
A broken bone in New York is the exact same broken bone in California. It's just a very clean, universal process.
Exactly. And it's comforting. We like things to be visible and easily categorized into neat little boxes. But then, you step into the world of the law.
Oh, yeah. The boxes disappear pretty fast.
Completely disappear. Specifically, the world of civil procedure. And suddenly, that metaphorical x-ray machine is just completely broken. We're looking at a landscape that is incredibly murky.
Muddy, yeah.
You might have a perfectly valid injury, right? A perfectly valid lawsuit. But if you don't know the exact, highly specific rules about where to file it and which laws apply to it, your case is just dead on arrival.
It is the absolute definition of diagnostic muddy waters. I
Mhm.
mean, in the law, simply walking across the street to a different courthouse can completely change the reality of your case.
Which is wild to think about.
It really is. It can literally dictate whether you win or lose. And that's just incredibly daunting for anyone to navigate.
Which is exactly why we have a very specific focus today for this deep dive. If you're listening to this and you're staring down the barrel of the bar exam, specifically the MBE, and you're trying to navigate these dense legal concepts while English is your second language, civil procedure can feel like an absolute nightmare.
A total maze.
Right. So today we are drawing you a map. We are taking a comprehensive guide to two of the most heavily tested, the most difficult pillars of civil procedure. We're talking federal venue and the Eerie doctrine.
Huge topics.
Huge topics. Massive. And our mission is to explain them clearly, simply, and thoroughly. And we're going to do frequent recap checkpoints to really build out your mental study outline.
Because, honestly, understanding the underlying logic of the law is the absolute best way to memorize it.
Yeah.
If we only look at the what, it's just a list of boring rules. But if we explore the why, like the history and the policy behind why these rules even exist in the first place, the concepts actually lock into your brain.
Right. That makes sense.
Exactly. When you're sitting in that exam room, the answers will feel intuitive rather than just, rotely memorized.
So before we can even begin to figure out what laws apply to a lawsuit, we first need to figure out exactly which courtroom we are actually allowed to stand in, right? We have to find our location.
And that introduces our first major concept, which is venue.
Okay.
Venue is a really fascinating mechanism because it's so frequently confused with other types of jurisdiction.
Right, because there are a lot of them.
There are. In civil procedure, before a federal court can even hear a case, it needs three distinct things. First, it needs subject matter jurisdiction.
As MJ, yeah.
Right, SMJ. This is the court's constitutional power to hear the specific type of case. Second, it needs personal jurisdiction, PJ.
Which is power over the person.
Exactly, the court's constitutional power over the specific defendant. And third, it needs venue. And here's the thing, venue is not about constitutional power at all.
Really?
Yeah, it's entirely about geography. It basically asks, out of all the federal courts in the entire country that have the constitutional power over this case, which specific physical judicial district is the proper and fair place to actually hold the trial?
Okay, I want to make sure the distinction between those three is just crystal clear for the listener. Let me try an analogy.
Go for it.
Imagine you're going to a massive, famous theme park.
Ugh.
Subject matter jurisdiction means you actually have a valid ticket to enter the park itself.
Right, the park is legally allowed to let you in.
Exactly. Personal jurisdiction means the security guards at the front gate have the legal authority to physically stop the defendant and pull them into the park with you.
I like it.
But venue is simply figuring out exactly which specific ride inside the park you're supposed to go to.
That is a great visualization. Yeah, you're inside the park, you have the right to be there, and the defendant has been successfully brought inside. But you can't just wander around and go anywhere you want. You have to go to the correct designated location. And, the history behind why we care about this specific location is actually quite interesting.
Oh, how so?
Well, under Old English common law, there was this really strict difference between what courts called local actions and transitory actions.
Local versus transitory. What did that mean in, everyday practice?
So a local action almost always involved the title to real property. Land, a farm, a house.
Okay.
The old rule was that you absolutely had to bring the lawsuit in the specific local court where that land was physically located.
I guess that makes sense.
It does. The logic was purely practical. Back in the day, a sheriff in one county had absolutely no power to cross the county line and force someone to hand over a piece of land in another jurisdiction.
Right, they couldn't just ride their horse into the next town and start giving orders.
Exactly. So only the local court could truly enforce a ruling about local land. On the other hand, a transitory action was based on events that could have happened anywhere.
Like what?
A bar fight, a broken contract, an unpaid debt. Those actions could travel or transition to different courts wherever the defendant was eventually found.
Okay, so do we still use that distinction today? Like, if you're taking the MBE and studying for the federal rules, do you need to worry about whether your case is local or transitory?
In the federal system, no. The rules have totally been modernized.
Oh, thank goodness.
Yeah. Today, in the federal system, local actions and transitory actions are treated exactly the same under the federal venue statutes. However, and this is a quick note of caution, many state courts still use this old distinction.
Good to know.
But for federal civil procedure on the MBE, you basically have one main set of rules for everything.
That is a relief. Just one set of rules. And that main set of rules for general federal venue is found in a statute called Section 1391, right?
Yes, Section 1391.
Okay, so if you are taking the MBE, Section 1391 needs to be permanently burned into your memory. Let's break down the three main prongs of this general rule. I'll read the statutory language, and you translate it into everyday English.
Sounds like a plan.
Okay. Prong number 1 says, venue is proper in a judicial district in which any defendant resides, if all defendants reside in the same state in which the district is located.
Okay, let's ground that in a really concrete example. Imagine you, the plaintiff, want to sue two people for a single breach of contract.
Okay. Defendant A and Defendant B.
Right. Defendant A lives in the Northern District of Texas. Defendant B lives in the Southern District of Texas. Because they both live in the exact same state, Texas, you're allowed to file the lawsuit in either the Northern District or the Southern District.
Okay, so any district where at least one of them lives.
Yes, exactly. The key phrase to circle in your notes is same state. If all defendants live in one state, any district where at least one of them lives is a proper venue.
Okay, but what if Defendant B decides to pack up and move across the border to Oklahoma right before the lawsuit is filed?
Oh.
So now Defendant A is in Texas and Defendant B is in Oklahoma. Does prong 1 still work?
No, it completely fails.
Really? Totally fails?
Completely. Because all defendants no longer reside in the same state, you just can't use prong 1 at all. You have to move down the list to see if another rule applies.
Understood. Okay, that brings us to prong number 2. Venue is proper in a judicial district in which a substantial part of the events or omissions on which the claim is based occurred, or where a substantial part of the property that is the subject of the action is located.
This one is honestly usually the most intuitive for students. It simply means you can sue someone where the bad thing actually happened. If two cars crash in the Middle District of Florida, then the Middle District of Florida is a proper venue because a substantial part of the events occurred there.
Makes sense.
The underlying policy is just efficiency. The law wants the trial to happen physically close to where the police officers are, where the skid marks on the road are, and, where the witnesses live.
That word substantial seems like it could cause arguments, though.
Oh, it does.
Like, what if it's a products liability case? Say the car was designed in Michigan, manufactured in Ohio, and then it actually crashed in Florida.
You've hit on a very common litigation battleground there. Substantial does not mean the most important part. It just means a meaningful portion of the events.
Okay.
In your example, a plaintiff might actually have the choice of filing in Michigan, Ohio, or Florida.
Oh, wow. All three?
Yeah. All three might be considered places where a substantial part of the events or omissions occurred. A case can definitely have more than one proper venue under prong 2.
Okay, so multiple venues can be proper. Now let's look at prong number 3, the fallback provision.
The safety net.
Right. It states, if there is otherwise no judicial district in which the action may be brought, venue is proper in a judicial district in which any defendant is subject to personal jurisdiction with respect to such action. When does this actually, come into play?
Honestly, rarely.
Really?
Yeah, it's truly a safety net. You only look at prong 3 if prong 1 and prong 2 completely fail to provide a venue. Anywhere in the United States.
Give me a scenario where that actually happens, because it sounds hard to do.
Well, imagine two Americans, one from New York and one from California. They go on vacation to France.
Okay, there.
Right. While in Paris, they get into a massive fight and one injures the other. The New Yorker wants to sue the Californian in an American federal court. Let's run the test.
Okay.
Prong 1. Do all defendants reside in the same state? No, we have a New Yorker and a Californian. Prong 1 fails.
Right.
Prong 2. Did a substantial part of the events happen in a U.S. judicial district? No, it happened in Paris, France. Prong 2 fails.
Ah, I see. So without prong 3, the plaintiff would be completely locked out of the U.S. federal courts, even though both parties are literally Americans.
Exactly. The law says, we need to give the plaintiff somewhere to sue.
So under prong 3, you can sue in any district that has personal jurisdiction over any of the defendants.
That makes sense.
But remember, the examiners love to trick you by offering prong 3 as an option when prong 1 or 2 actually works. You only use the fallback if the first two are impossible.
Okay, so let's do an MBE recap checkpoint right here.
Yeah.
If you're summarizing this for your mental checklist, here's the recap. First rule, you can sue where any defendant lives as long as they all live in the same state.
Right.
Second rule, you can sue where the major events happened or where the disputed property is.
Yep.
Third rule, the safety net. If and only if the first two options draw a total blank, you can sue anywhere you have personal jurisdiction over a defendant.
That is the perfect mental checklist. If you lock down those 3 rules, you basically have the foundation of federal venue mastered. Awesome. Now, we just established in our first rule that venue often depends on where a defendant resides. But what does the word residence actually mean in the eyes of the court?
Oh.
Because legal definitions often twist normal dictionary definitions. If I'm a human being, where do I reside?
For human beings, which the law calls natural persons, the rule is actually pretty straightforward. A natural person resides in the judicial district where they are domiciled.
Domicile.
Yes, domicile is a very specific legal word. It basically means the place where you have your true, fixed, permanent home and where you intend to stay indefinitely.
Okay, let me push back on intend to stay. What if I'm a student from New York, but I moved to Massachusetts for 3 years to attend law school?
Okay.
Rent an apartment, I buy groceries in Massachusetts. I basically live there for most of the year.
Yeah.
Am I domiciled in Massachusetts?
Generally, no.
Really? Even after 3 years?
Even then, unless you have formed a specific intent to stay in Massachusetts permanently after graduation, your domicile remains New York. You're just visiting Massachusetts temporarily for an educational purpose. Domicile requires both physical presence and the mental intent to make it your permanent home.
Okay, that mental intent part is huge.
It is. Furthermore, the venue statute explicitly notes that this domicile rule applies equally to non-citizens who are lawfully admitted for permanent residence in the U.S.
Okay.
So for venue purposes, a permanent resident alien is treated identically to a U.S. citizen. They reside where they are domiciled.
Okay, human beings are simple enough. One domicile, one residence. But what about a business? A corporation doesn't have a heartbeat. It doesn't have a home where it sleeps. How does Section 1391 define residence for a business entity?
This is a massive trap for students.
Oh, boy.
The rule for business entities is incredibly broad. An entity with the capacity to sue and be sued, whether it's an incorporated business like a corporation or an unincorporated business like an LLC, is deemed to reside, if it is a defendant, in any judicial district in which the entity is subject to personal jurisdiction with respect to the civil action in question.
Wait, hold on. If it resides everywhere, it has personal jurisdiction. A massive company like Amazon or Apple essentially resides in every single judicial district in the country.
Yes. For the purposes of being sued as a defendant, a massive national corporation is a resident of essentially everywhere.
That's crazy.
But let's look at a slightly more nuanced example to see how this gets tested on the MBE. Let's take X Corporation.
Okay, X Corporation.
Imagine, X Corporation is legally incorporated in Delaware. It has its main headquarters, its principal place of business in Colorado.
Delaware and Colorado, got it.
And it maintains one small regional sales office in Orlando, Florida. Now, Orlando is in the U.S. Middle District of Florida. X Corporation does absolutely no business anywhere else in Florida. No sales in Miami, no offices in Tallahassee.
Okay, so Delaware, Colorado, and Orlando. If I want to sue X Corporation, where does it reside for federal venue?
It resides in all 3 of those places.
All 3?
Yes. For venue purposes, X Corporation resides in the District of Delaware, it resides in the District of Colorado, and it resides in the Middle District of Florida. Because in all 3 of those specific districts, The corporation has enough contacts to be subject to personal jurisdiction.
So wait, a human being only has one residence, but a business can have 3, or 10, or 50.
Exactly. But notice the crucial limitation in that Florida example.
Okay.
I said Orlando is in the Middle District of Florida, and they do no business anywhere else in the state.
Right.
Florida has multiple districts, the Northern, Middle, and Southern districts. X Corporation would not be a resident of the Southern District of Florida down in Miami.
Why not? They're in Florida.
Because for corporate venue, you have to pretend that every single judicial district is its own separate tiny state. You have to analyze the corporation's contacts with that specific district.
Oh, I see.
Just having an office in Orlando doesn't give a court in Miami personal jurisdiction over you.
That is a tricky distinction. You can't just say the state of Florida.
Yeah.
You really have to pinpoint the district.
Exactly.
Now, what if the business is not the defendant? What if the business is the one actually filing the lawsuit as the plaintiff?
If the business entity is the plaintiff, the rule completely flips. It becomes very strict.
How strict?
A plaintiff entity is deemed to reside only in the judicial district in which it maintains its principal place of business, just one location.
Wait, what? The double standard. Why does a defendant business live everywhere, but a plaintiff business only lives in one place?
Policy. The courts do not want to give a massive corporation the power to forum shop and file a lawsuit against a small defendant in any random district across the country just because the corporation happens to sell products there.
That makes total sense.
By limiting the plaintiff corporation to its principal place of business, the law prevents them from weaponizing their size to secure a convenient venue for themselves at the expense of the defendant.
I see. So it's basically a geographic limit on corporate power.
Yeah.
Speaking of corporate rules, let me bring up diversity jurisdiction for a second. We're talking about residence for venue. Do business entities have the same citizenship for diversity as they do residence for venue?
I'm so thrilled you asked that because this is where a lot of points are lost on the MBE. You must keep these two concepts strictly separated in your mind.
Okay, listener, perk up your ears.
The broad rule we just discussed, where a business resides anywhere it has personal jurisdiction, is only for venue. It absolutely does not apply when you are determining citizenship for diversity jurisdiction.
Break that down for me. Give me an example of how a partnership is treated for diversity versus venue.
Let's take a law firm that is structured as a partnership. For diversity jurisdiction, the rule is that a partnership takes on the citizenship of every single one of its partners.
Okay.
If it has partners living in 50 states, the partnership is considered a citizen of 50 states. That destroys diversity jurisdiction almost immediately. But if you're looking at venue, we completely ignore where the partners live. For venue, we just look at the partnership as a single unified entity and ask, in which judicial districts does this entity have personal jurisdiction?
So citizenship for diversity and residence for venue are two completely different legal tests.
Yes. They share some vocabulary, but the math is entirely different.
Got it. Okay, one last residence question. What about a defendant who does not live in the United States at all, a non-resident?
Under Section 1391(c)(3), a defendant who is not a resident of the United States may be sued in any judicial district.
Anywhere.
Anywhere. Furthermore, if you are suing multiple people, say one U.S. resident and one non-U.S. resident, you just completely ignore the non-resident when you're calculating the proper venue. You just apply the normal rules to find a proper venue for the U.S. resident, and the foreign defendant can simply be dragged into that same district.
Okay, listener, let's run another quick mental recap to lock in this segment. Human beings reside at their domicile, the place they intend to stay indefinitely. Defendant businesses reside essentially everywhere they're subject to personal jurisdiction. But a plaintiff business is strictly limited to its principal place of business. And you absolutely cannot mix up the rules for venue residence with the rules for diversity citizenship.
Exactly. If you can navigate the corporate residence rules, you will confidently breeze through most venue multiple choice questions.
So we've established the general rules for, everyday people and normal businesses. But the government operates by its own set of rules, doesn't it? Like, if I want to sue a federal agency, do I have to travel all the way to Washington, D.C.?
Not necessarily. There are special venue provisions for specific types of cases.
Okay.
The first one involves federal officials. Under Section 1391, if you are suing an officer or employee of the United States government who is acting in their official capacity, the venue options are actually broadened.
Broadened how?
You can sue them where the defendant resides or where a substantial part of the events occurred, or you can sue them in the judicial district where the plaintiff resides.
Wait, really? I can sue the government in my own hometown, even if the events happen somewhere else. Why?
As long as the lawsuit doesn't involve real property, yes. The reasoning is that the federal government is massive, right? And it has lawyers stationed in literally every district in the country.
Sure.
It's much easier for the Department of Justice to defend a lawsuit in your home district than it would be for you, a private citizen, to travel across the country to sue them. It levels the playing field.
What about if a mail truck hits my car? That's a tort. Does that fall under the same rule?
That actually falls under the Federal Tort Claims Act, or FTCA. Section 1402B says that for a tort claim against the federal government, venue is proper either where the plaintiff resides or where the act or omission occurred.
Okay, those are pretty straightforward exceptions. But what about cases that start in state court and get moved to federal court? The process of removal.
Removal is a huge topic. Under Section 1441A, if a plaintiff files a lawsuit in a state court and the defendant has the legal right to remove that case to the federal court system, the venue is completely automatic.
It's automatic.
Yes. It goes directly to the federal district court that geographically encompasses the state court where the lawsuit was originally filed.
So if I file in a state courthouse in Austin, Texas, and the defendant removes it, it just snaps to the federal courthouse sitting in Austin, Texas.
Exactly. It is a straight geographic mapping. And a crucial point to remember for the exam. When a case is removed, it is completely immaterial if that federal court would have been an improper venue had the plaintiff filed there initially.
Really?
Yeah, the removal statute just bypasses the normal Section 1391 venue rules entirely.
Okay, so we know the rules and we know the exceptions. But what happens in the real world when a lawyer messes up? What if the plaintiff files the lawsuit in a completely wrong venue, like a district that does not meet any of these rules we just discussed? Does the judge automatically throw the case in the trash?
This is where we have to discuss the most critical concept for the MBE regarding venue. Waiver.
Waiver.
Right. Let's compare venue to subject matter jurisdiction. Earlier, we said subject matter jurisdiction is the court's fundamental constitutional power to hear a case. Can a party waive subject matter jurisdiction? Like, can a defendant say, I know this federal court doesn't technically have the power to hear this local state dispute, but I agree to let them hear it anyway because I like this judge.
Oh, no way. The Constitution wouldn't allow that.
Exactly. Subject matter jurisdiction can never be waived. It is a structural limitation on the court. Even if both parties are begging the judge to hear the case, if there is no subject matter jurisdiction, the judge must dismiss it.
They have no choice.
None.
No.
In fact, a party can bring up the lack of subject matter jurisdiction at any time, even years later on the very last day of an appeal. The court can even bring it up themselves.
The venue is different.
Venue is entirely different. Venue is not about constitutional power. It's just a statutory rule designed for the geographic convenience of the parties. Therefore, it is entirely waivable. If a plaintiff sues a defendant in the completely wrong venue, but the defendant looks at the map and thinks, you know what, this courthouse is actually pretty close to my house, I don't mind, they can choose to waive their objection and proceed with the trial.
So if it's waivable, what does the defendant actually have to do to object to it? Like, if I'm a defendant and I hate the venue, how quickly do I need to speak up?
You have to speak up immediately. The federal rules of civil procedure are brutal about this.
How brutal?
Under Rule 12b3, a defendant must object to improper venue in their very first response to the lawsuit. This means they must raise the objection either in a pre-answer motion to dismiss, or if they decide not to file a pre-answer motion, they must explicitly state the objection right there in their formal answer to the complaint.
What happens if a lawyer files the answer, denies all the facts, demands a jury trial, but just totally forgets to mention that the venue is wrong? Can they file a correction a week later?
Usually no. If the objection to venue is not asserted in that very first responsive pleading or motion, it is automatically and permanently waived.
Wow.
You lose the right to complain about it forever. By participating in the lawsuit and answering the facts without objecting to the location, the law assumes you have consented to the improper venue.
That is terrifying for a young lawyer. If you miss that detail on day one, you are just trapped.
Completely.
Listener, keep this contrast sharp in your mind. Subject matter jurisdiction is power. It can never be waived, and you can object to it at any time. Venue is convenience. It is entirely waivable, and if you do not object in your very first Rule 12 motion or answer, you lose the right forever.
The examiners absolutely love testing that distinction. They will give you a fact pattern where a defendant tries to object to venue 3 months into the trial, and the answer is always that they are too late.
Okay, so let's say the defendant does object properly and on time, or let's say we are in a proper venue, but it's just a really inconvenient place for everyone. Can we pick up the lawsuit and move it to a different federal court?
Yes, the federal system has a mechanism for this. It's called a change of venue, or a transfer. But the rules for transferring a case change drastically depending on whether the original court was a proper venue or an improper venue. Let's look at the good scenario first. Section 1404A.
Under 1404, the plaintiff filed the lawsuit in a perfectly valid, proper venue under the rules. But maybe all the witnesses live 3 states away. What happens?
Section 1404A allows a district court to transfer a civil action to any other district where it might have been brought originally. The statute says this is done for the convenience of parties and witnesses in the interest of justice.
Who asks for this? Just the defendant?
Either the plaintiff or the defendant can file a motion to transfer for convenience. The judge can even order it on their own initiative.
Oh, really?
Yeah, but the burden of proof is heavily on the party asking for the transfer. You can't just say, the other court is slightly better. You have to convince the judge that the new court is significantly more convenient.
What if 2 massive corporations signed a contract? And buried in the fine print, it says, any lawsuits regarding this contract must be filed in the Southern District of New York. Does the judge care about that?
The judge cares immensely. That's called a forum selection clause.
Right.
The Supreme Court, in a famous case called MS Bremen v. Zapata Offshore Company, ruled that forum selection clauses are highly significant factors. The courts want to respect the freedom of contract. If sophisticated parties agreed in advance where they wanted to litigate, the judge will almost always enforce it and transfer the case there, unless doing so would be wildly unreasonable or fundamentally unjust.
I noticed an interesting quirk in the notes here. It says a court can transfer a case under 1404A, even if the transferring court lacks personal jurisdiction over the defendant.
That's right.
How can a court do anything if it doesn't have power over the defendant?
It's a pragmatic loophole. Imagine a plaintiff files in a proper venue, but mistakenly believes the court has personal jurisdiction over the defendant. The defendant objects. Normally, the judge would have to dismiss the case. But instead of forcing the plaintiff to pay new filing fees and start completely over in a new state, the judge can say, I don't have power over this defendant, but a court in California does. To save time and money, I'm going to use 1404 to just transfer this file to California. It's basically an act of judicial mercy.
Okay, so 1404 is for transferring from a proper venue. But what if the plaintiff messed up entirely? The original venue is completely improper, and the defendant objects on time.
That brings us to Section 1406A. When the original venue is improper, the judge has a choice. The judge must dismiss the case entirely, or if it be in the interest of justice, the judge can transfer the case to a district where it actually could have been brought.
So they prefer to transfer.
Again, courts generally prefer to transfer rather than dismiss to save everyone time and money, but they do have the power to just throw it out.
Okay, so we know how the physical case file moves between buildings. But here is where it gets incredibly complicated. When you move a lawsuit from a federal court in Pennsylvania to a federal court in Mississippi, what happens to the law?
The traveling law trap.
Right. Does the law travel with the lawsuit, or do you adopt the law of the new state?
This is the intersection of venue and choice of law, and it is a brilliant exam trap. The answer depends entirely on why the case was transferred. Let's look at diversity cases based on state law.
Yep.
If the case is transferred under Section 1404, meaning the original venue was proper but we are moving it just for convenience, the new court, the transfer court, must apply the exact same state law that the original court would have applied. The law travels with the case.
This sounds like the Ferenz case. Let me try an analogy. Tell me if this works.
I'm listening.
It's like packing a suitcase for a trip.
Yeah.
If you decide to move voluntarily because you want a more convenient vacation, that's Section 1404. The original venue is proper.
Yeah.
You get to pack your own suitcase and take your home laws with you to your new destination.
Yes, exactly. You're traveling legally, so you get to keep your legal luggage. But let me tell you the actual facts of Ferenz v. John Deere to show you just how extreme this rule is.
Please do.
A man named Mr. Ferenz lost his hand in a combine harvester accident in Pennsylvania. He waited 3 years to file a lawsuit. The problem: Pennsylvania had a 2-year statute of limitations. His case was dead in Pennsylvania.
Oh, wow. So what did he do?
His lawyers realized that Mississippi had a 6-year statute of limitations, and because John Deere did business everywhere, Mississippi was technically a proper venue.
No way.
So he filed his lawsuit in a federal court in Mississippi, but all the witnesses and evidence were in Pennsylvania. So as soon as he filed it in Mississippi, he requested a Section 1404 convenience transfer back to Pennsylvania.
He filed Mississippi just to grab their 6-year time limit and then transferred it right back home? Did the Supreme Court allow that?
They did. The Supreme Court said that in a 1404 transfer, the law of the transfer court travels with the case even if the plaintiff is the one asking for the transfer.
That is wild.
The Pennsylvania federal judge was forced to apply the Mississippi 6-year statute of limitations. It's a wild outcome, but it proves the absolute nature of the rule. 1,404 transfers take their suitcase with them.
Okay, that is a crazy story, but it makes the rule unforgettable. Now, what if the transfer is under Section 1406? What if the plaintiff filed in an improper venue and the case gets transferred to fix the mistake?
Extending your analogy, if you're kicked out because you trespassed, meaning you filed in an improper venue, your suitcase is confiscated at the border.
Confiscated?
You do not get to take your laws with you, and you don't get to run around naked. The new state forces you to wear its clothes. In a diversity case transferred under Section 1406 for improper venue, the new court will apply its own state's choice of law rules.
Why the harsh difference?
Because the court doesn't want to reward bad behavior. If we let the law travel under 1406, a plaintiff could intentionally file a lawsuit in a completely wrong court just to steal that state's favorable laws, knowing the judge would eventually transfer the case to the correct court.
Right, they just game the system.
Exactly. By confiscating the suitcase, the law ensures you don't benefit from filing in an improper venue.
That is deeply logical. The law punishes the mistake. What about cases that aren't based on diversity? What about federal question cases? Do they have a traveling law rule?
In federal question cases, we're dealing with federal law, not state law. In theory, federal law is supposed to be identical everywhere in the country.
In theory.
Right. But different federal appellate circuits, like the Ninth Circuit in California versus the Second Circuit in New York, sometimes interpret federal statutes differently. If a federal question case is transferred to a district court in another appellate circuit, the interpretation does not travel.
Oh, really?
Yeah. The new district court will simply apply federal law as interpreted by its own court of appeals. The new court listens to its own boss, regardless of where the case came from.
Listener, this traveling law concept is high yield for the MBE. Let's lock it down. 1404 is a transfer from a proper venue for convenience. The law travels with the case. 1406 is a transfer from an improper venue to fix a mistake. The law does not travel, and the new court uses its own rules.
If you can visualize that suitcase being packed or confiscated, you will never get a transfer of law question wrong.
So we've spent all this time talking about moving cases between different federal courts inside the United States. But what if the better or more convenient court is not just in another state? What if it's in another country entirely? Or what if the proper court is a state court, not a federal one?
That introduces the doctrine of forum non-conveniens. This is a Latin phrase that simply means inconvenient forum.
Inconvenient forum. Okay.
This doctrine allows a court to completely dismiss an action, even if the court has perfect personal jurisdiction, perfect subject matter jurisdiction, and venue is technically proper.
Wow, even if everything is perfect.
Yes. The court looks at the case and says, yes, we legally have the power to hear this, but doing so would be vastly, terribly inconvenient for everyone involved, and there is a much better alternative court available somewhere else.
But wait, if they want to move it because it's inconvenient, why not just use a Section 1404 transfer like we just discussed?
Because of sovereignty. Section 1404 only allows a federal judge to transfer a case to another federal judge within the United States federal system. A U.S. federal judge has absolutely no authority to transfer a case to a court in Paris, France. And a federal judge cannot transfer a case down the street to a New York state court. They can't place a file on another sovereign's desk.
That makes sense.
Therefore, when the ideal alternative court is a foreign court or a state court, the federal judge cannot transfer it. Their only option is to use forum non-conveniens to dismiss the case entirely, which forces the plaintiff to go file a brand new lawsuit in that foreign or state court.
Can you give me a real-world example of when this happens?
A classic example is the Bhopal disaster. A massive, tragic gas leak occurred at a chemical plant in India, killing thousands of people. The victims tried to sue the American parent company, Union Carbide, in a U.S. federal court.
Okay.
The U.S. court had jurisdiction, and venue was technically proper where the corporation was headquartered. But the judge looked at the case and said, the accident happened in India, the victims are in India, all the evidence, the plant, the local regulations, the witnesses, they are all in India. It is absurdly inconvenient to try this case in New York.
Right.
So the U.S. judge dismissed the case under forum nonconvenience, forcing the plaintiffs to litigate in the Indian court system.
I see. So it always results in a dismissal. Do state courts use this doctrine too?
Yes, state courts use the common law doctrine of forum nonconvenience very frequently. Because, again, a state court judge in Ohio cannot transfer a case to a state court judge in California. They're different sovereign systems.
So the Ohio judge would dismiss the case so it could be refiled in California.
Exactly. State judges balance several factors. Is there a valid alternative forum? Where is the evidence? Are we going to have to translate documents? It's a balancing test to find the most logical place for the trial.
All right, listener. We've figured out the map, we've picked our court, we've settled into our venue, and the judge hasn't dismissed us. The trial is about to begin. The federal judge sits at the bench, looks at the lawyers, and asks the most terrifying question in civil procedure. What law am I supposed to actually apply to this case?
Yes. The Eerie doctrine.
I call it the witch law monster. It strikes fear into the hearts of law students everywhere, but we are going to tame it today.
The entire doctrine revolves around one fundamental problem. When a lawsuit is filed in a federal district court, the judge has to decide whether to apply federal law or state law to the dispute.
And why is that such a problem?
To understand why this is a problem, you have to look at history. For nearly 100 years, federal courts operated under an old case called Swift v. Tyson. Under Swift, federal judges in diversity cases basically ignored state common law and just made up their own general federal common law.
Wait, so a federal judge could just invent a law that contradicted the state's law, even if the dispute was purely local?
Exactly, and it caused absolute chaos and massive unfairness. A plaintiff would look at a state court and realize they'd lose under state law. So they would manufacture diversity jurisdiction, walk across the street to the federal courthouse, and win under the judge-made federal law. It encouraged rampant forum shopping.
How do we fix it?
In 1938, the Supreme Court handed down Erie Railroad Co. v. Tompkins. Mr. Tompkins was walking along a railroad track in Pennsylvania and was hit by an open door on a passing train. He sued in federal court in New York.
Okay, a diversity case.
Right. Under Pennsylvania state law, he was a trespasser, and the railroad owed him almost no duty of care. He would lose. But under the old general federal common law, the railroad owed him a higher duty, and he would win.
What did the Supreme Court do?
The Supreme Court finally stepped in, overturned Swift v. Tyson, and said, there is no general federal common law. In a diversity case, the federal court must apply the substantive law of the state.
Okay, so let's establish the baseline rule. If it's a federal question case like suing under a federal civil rights statute, Eerie doesn't matter.
Correct. If it's a federal question claim, you use federal law for everything. The Eerie monster only wakes up when we are dealing with a federal diversity claim. This is when the plaintiff and defendant are from different states, but they are suing over a normal state law issue, like a car crash or a contract.
So the basic rule of Eerie is, in a diversity action, the federal judge must apply state substantive law, but can apply federal procedural law. Basically, we're asking a federal judge sitting in a federal building to put on a state judge hat when looking at the core facts of the case.
That's a great way to put it.
They have to pretend they are a state judge deciding who breached the contract. But when it comes to managing the courtroom, how many days you have to file a motion, what size paper to use, they keep their federal hat on.
That is the essence of it. But as any lawyer knows, the line between the substantive and procedural is incredibly blurry. Something that looks like a minor courtroom procedure can actually dictate who wins the case.
Definitely.
So the Supreme Court developed an analytical framework over decades to help judges figure it out. Let's walk through this framework step by step.
All right, step one. The judge is staring at a state rule and a federal rule. What is the first question?
Step one. The judge asks, is there actually a conflict between the state law and the federal law? If the state rule and the federal rule dictate the exact same outcome, there is no conflict. The judge just applies the rule harmoniously, and the Eerie analysis stops before it even begins.
Okay, but on the MBE, there is always a conflict. So, step two. The state rule says one thing, the federal rule says another. What does the judge ask next?
Step two. The judge asks, Is there a valid written federal statute or a federal rule of civil procedure that directly covers this disputed issue?
And if there is?
If the answer is yes, the federal judge must apply the federal rule. Federal law wins. This rule comes from a famous case called Hanna v. Plummer.
Tell me about Hanna v. Plummer. Why did the federal rule win?
In Hanna, the plaintiff sued a defendant's estate over a car crash. The plaintiff served the legal papers by leaving them with the defendant's wife at their house. The federal rules of civil procedure explicitly said this was a perfectly valid way to serve papers.
Okay.
But Massachusetts state law said that when suing an estate, you had to hand the papers to the executor directly in person. So there's a direct clash between a written federal rule and a state law.
What happened?
The Supreme Court said that because Congress gave the Supreme Court the constitutional power to write procedural rules for its own courts, a valid federal rule of civil procedure will always trump state law, even if it changes the outcome of the case.
Okay, so if there is a written federal rule on point, federal wins. But what if there is no specific written federal rule? What if it's just a general practice or a judge-made rule? What is step 3?
Step 3. If no written federal rule is directly on point, the judge has to decide between using federal common law or state law. To make this decision, the judge must look to the core philosophy of Eerie, which we call the twin aims.
The twin aims. This is the heart of the doctrine. What are they?
The twin aims are 1. Preventing forum shopping, and 2. Preventing the inequitable administration of the laws.
Okay, let's break those down.
Let me explain forum shopping clearly. Forum shopping is when a plaintiff realizes that the rules in federal court are so different from state court that they will win in federal but lose in state. So they shop for the federal forum just to get an unfair advantage.
Right.
The Eerie doctrine hates this. The law should be consistent whether you walk into a state building or a federal building.
And the second aim, inequitable administration.
It's the other side of the same coin. It is deeply unfair if an out-of-state citizen gets a completely different, more favorable legal result in federal court than a local citizen would get in state court for the exact same car crash.
Yeah, that makes sense.
So, in step 3, the judge asks, if I choose to ignore state law and apply federal common law instead, will it cause people to flock to federal court, or will it cause unfairness?
And step 4 is the result of that question.
Exactly. Step 4. If ignoring the state law would cause forum shopping, the judge must apply the state law. They do this to mirror the state court and keep everything fair.
Are there any exceptions to this mirroring? Does the federal court ever just say, I know this is a state issue, but I'm a federal judge and I am going to do it my way?
Yes, there are exceptions, and they are tested. The judge might apply federal law if there are overwhelming countervailing federal interests at stake. This comes from a case called Byrd.
Okay, Byrd.
Or, conversely, the federal court might bend over backwards to accommodate state law, which happened in a fascinating case called Gasparini.
The outline specifically flagged Gasparini. Unpack that one for me. Why did the federal court narrow its own rules?
Gasparini v. Center for Humanities is a brilliant illustration of this balancing act. Gasparini was a photographer who sued for lost slides, and a federal jury awarded him a massive amount of money.
Okay.
Under New York state law, appellate courts were given special power to review jury awards and reduce them if they deviated materially from reasonable compensation. It was a strict standard designed to cap runaway juries.
That sounds like a big conflict.
It was, because the 7th Amendment of the U.S. Constitution strongly protects federal juries, basically saying an appellate court cannot re-examine facts decided by a jury. So we have a huge clash. State law says review the jury. Federal law says leave the jury alone.
How did the Supreme Court resolve a clash with the 7th Amendment?
They compromised. They realized the New York law was technically procedural, but it had a deeply substantive purpose to control excessive damages. To protect that state interest without violating the federal constitution, the Supreme Court created a hybrid rule. They said the federal trial judge must apply the strict New York deviates materially standard when deciding whether to grant a new trial, but the federal appellate court would only review the trial judge's decision under a loose abuse of discretion standard.
Wow.
It was a surgical way to accommodate the state's substantive policy while keeping federal appellate procedure intact.
That is fascinating. The federal court actively narrowed its own power to respect the state's underlying goals. Okay, listener, the Eerie flowchart is abstract, but you need it for the essay portion of the exam. Let's review the steps.
Go ahead.
Step 1. Is there a conflict? If no, apply harmoniously. Step 2. Is there a written federal statute or rule of civil procedure on point? If yes, apply it. That is HANA. Step 3. If no written rule, look at the twin aims. Prevent forum shopping and prevent unfairness. Step 4. If ignoring state law causes forum shopping or changes the outcome, you must apply state law. And remember, the ultimate goal is to make the federal court act as much like the state court across the street as possible.
That is an excellent summary. Now, while the flowchart is great for essays, for the multiple choice questions, you usually just need to know what the Supreme Court has already definitively categorized as substantive versus procedural. There are specific examples that show up on the test over and over again.
Let's run through the list. Give me the major examples of substantive law where the federal judge must use state law.
First, the elements of a claim or defense. If you are suing for a tort-like negligence, the definition of what constitutes negligence is purely state law. The federal judge cannot invent their own definition.
Okay, that's clear.
Second, statutes of limitations and tolling provisions.
Wait, I need to push back on that. A statute of limitations. The time limit you have to file a lawsuit sounds purely procedural. It is literally just a deadline on a calendar. Why is it substantive?
You're not alone in thinking that. It is the most common trap on the exam. The Supreme Court addressed this in a case called Guarantee Trust Company York.
What happened in that case?
The plaintiff sued a bank in federal court based on diversity. The New York State statute of limitations had already expired. The case was dead under state law. But the plaintiff argued that in federal court, time limits are just flexible procedures, so the judge should let the case proceed.
What did the Supreme Court say?
The Supreme Court said absolutely not. They created the outcome determinative test. They asked, if we apply the federal rule instead of the state rule, will it drastically change the outcome of the case? Yes.
Because the case would survive.
Exactly. In state court, the plaintiff loses immediately. In federal court, the plaintiff gets to go to trial. If federal courts ignored state time limits, every plaintiff with an expired claim would run to federal court. It would cause massive forum shopping.
I see.
Therefore, because it dictates the life or death of the case, a statute of limitations is considered substantive, and the federal court must apply the state time limit.
Okay, that logic is ironclad. If it dictates life or death, it's substantive. What's the third substantive category?
The burden of proof. The rules regarding who has to prove what and how heavy that burden is are considered substantive. A federal judge must use the state's rules for the burden of proof.
Okay, those are the substantive examples. Now, what about procedural law? When does the federal judge get to ignore state law and use federal law?
First, judge-jury allocation. We touched on this with the Byrd case. If there is a jury trial in federal court, the federal rules completely control what facts the jury gets to decide versus what the judge gets to decide.
Even if state law disagrees.
Even if state law mandates that a judge must decide a certain issue, the federal court ignores it. The federal system fiercely protects the role of the jury as an essential characteristic of the federal system.
Okay, what else?
Second, assessment of attorney's fees as a sanction. If a lawyer acts in bad faith during litigation, a federal judge has the inherent procedural power to sanction them with attorney's fees, even if the state law doesn't allow it. It's about controlling the decorum of the federal courtroom.
Listener, these categories are pure gold for the MBE. Statutes of limitations, substantive state law, burden of proof, substantive state law, right to a jury deciding facts, procedural federal law, elements of a claim, substantive state law. Memorize that list.
Exactly. Now we are moving into the final and perhaps most complex phase of our deep dive, determining state law and conflict of laws.
Okay, let's get into it.
So under Eerie, we just established that the federal judge must apply state substantive law. But what if the state's law is a total mystery?
What do you mean?
What if the state legislature has never written a statute about this specific issue, and the state judges have never clearly answered the question? How does a federal judge apply a law that doesn't exist yet?
Right. They can't just throw up their hands and say, I don't know. They have to decide the case.
Correct. The federal court is bound by the rulings of that state's highest court, usually called the state Supreme Court. If the highest court has spoken, the federal judge simply reads their opinion and follows it.
Easy enough.
But if the state's highest court has never ruled on the issue, the federal judge must essentially become a fortune teller. The federal court must try to predict how the state's highest court would rule if they were looking at the case today.
How on earth do they predict that? Do they look at, like, academic articles?
They look at everything, but mostly they look at decisions from the lower state appellate courts. The federal judge will generally follow the trends of the lower state courts unless there is a very strong, compelling reason to believe the state Supreme Court would disagree and overrule them.
Is there any other way?
Some states actually offer a lifeline called certification. The federal judge can write a formal question, send it to the state Supreme Court, and ask, how would you interpret this, and then wait for them to answer.
Okay, but what if they don't certify it? What if the federal judge makes a prediction, conducts an entire month-long trial based on that prediction, a verdict is reached, and the loser appeals? And then, while the case is sitting in the federal appellate court, the state Supreme Court suddenly issues a brand new ruling in an entirely different case that proves the federal judge's prediction was completely 100% wrong. What happens?
It is a nightmare scenario, but the Supreme Court has a strict rule for it, established in a case called Vandenberg.
Vandenberg, okay.
If the state's highest court issues a ruling after the federal trial is complete, but while the case is still pending on appeal in the federal system, the federal appeals court is bound by the new state ruling.
No way.
Yes, they have to apply the correct law, even if it means completely reversing the federal trial judge's prediction and forcing a new trial. The state Supreme Court is the ultimate boss of state law, and federal courts must bow to their latest word.
Wow. Talk about a plot twist for the lawyers involved. Okay, that covers predicting the law. Now, for the grand finale, conflict of laws.
Here we go.
We know the federal court in diversity applies the substantive law of the state it sits in. But what if the lawsuit involves a car crash in Maine, but the lawsuit is filed in Massachusetts? Which state's law do we use? Maine or Massachusetts?
This brings us to the Claxon rule. It's named after the case Claxon-Cohen v. Stentor Electric MFG Co.
Okay.
The rule is this. In a diversity action, a federal district court must use the conflict of law rules of the state in which the federal court is physically located. Let me repeat that because it is a vital layer of inception. The federal court uses the state's rules for deciding which state's law applies.
Let's slow down and unpack this. Why does the federal judge have to use the state's choice of law rules? Why can't the federal judge just look at the map and say, the crash happened in Maine, I'm using Maine law?
Because of Eerie. Think back to the twin aims, preventing forum shopping between the state courthouse and the federal courthouse across the street.
Right.
Imagine a Massachusetts state judge would look at a case and say, our state rules say we apply Massachusetts law to this. If a federal judge in Massachusetts could say, no, I'm going to use Maine law, then a plaintiff would forum shop.
They'd pick the court with the better law.
Exactly. They would choose the federal courthouse to get Maine law or the state courthouse to get Massachusetts law. The Claxon rule forces the federal judge to act exactly like the state judge across the street. If the state judge points to Maine, the federal judge points to Maine.
Okay, that makes perfect sense. The federal judge is just a mirror of the state judge. So let's walk through the specific car crash example from our source material. An accident happens in Maine. The plaintiff sues the defendant in a federal district court located in Massachusetts based on diversity.
Okay, the federal judge in Boston says, under Eerie, I need to use state substantive law. Under Claxon, I must look at Massachusetts state rules for conflict of laws to figure out which state. Let's assume Massachusetts conflict of law rules dictate that for tort cases, you always use the substantive law of the place where the injury occurred. So Massachusetts points the finger at Maine. The federal judge will therefore apply the substantive negligence laws of Maine.
So far, so good.
But here's the massive wrinkle. Maine and Massachusetts have very different rules regarding how a trial is run. Maine law says the defendant must prove the plaintiff was negligent. Massachusetts law says the plaintiff must disprove their own negligence.
Okay.
Furthermore, Maine has a specific rule about the burden of going forward, which means who has to stand up and present evidence first.
But wait, we just established a few minutes ago that under Eerie, the burden of proof is considered substantive law. So if the federal judge is applying Maine's substantive negligence law, they should apply Maine's burden of proof, right?
This is the ultimate MBE trick question. Listen closely. Yes, under Eerie, when balancing federal power versus state power, the Supreme Court decided the burden of proof is substantive. But under the state-to-state conflict of laws rules, a state might classify things differently. The definition of what is substance and what is procedure in a state conflict of laws analysis is not the same as the definition under Eerie.
My head is spinning. Explain how that works in the actual courtroom.
The Massachusetts state judge might look at the case and say, I will apply Maine's substantive negligence law because that's where the crash happened. But things like the burden of going forward and the specific mechanisms of presenting evidence are just courtroom management. For me, a Massachusetts state judge, those are procedural matters, so I'm going to use my own Massachusetts rules for that.
So the state judge is mixing and matching Maine negligence law, but Massachusetts courtroom procedure.
Yes. States do this all the time, and because the federal judge under Claxon must perfectly mimic the Massachusetts state judge, the federal judge will also mix and match. The federal judge will say, I am applying Maine's substantive law, but because the Massachusetts state court would treat the burden of going forward as a local Massachusetts procedure, I will also treat it as a Massachusetts procedure.
That is diabolical. A legal concept can literally be labeled substantive for an Eerie question, but labeled procedural for a state-to-state conflict question.
Yes, and it proves a profound point about the law. The labels substance and procedure are not scientific facts of nature. They are flexible tools that courts use to achieve different policy goals.
That's a great way to think about it.
Under Eerie, the Supreme Court uses the label substantive broadly to prevent forum shopping between federal and state courts. Under state conflict rules, state judges use the label procedural broadly so they can efficiently manage their own trials without having to learn another state's weird evidentiary rules.
That completely reframes how I look at these rules. They aren't just definitions in a dictionary. They're basically levers of power. Let's do our final MBE recap checkpoint. Listener, if you can grasp this, you are in the top tier of test takers. First, if a state's highest court hasn't ruled, the federal judge must predict how they would rule. If the state Supreme Court rules later during an appeal, the new ruling wins. That is Vandenberg.
Spot on.
Second, the Claxon rule. A federal court sitting in diversity must use the conflict of law rules of the state in which it is physically located.
Yes.
Third, the definitions of substance and procedure change depending on the context. A state might use another state's substantive law, but apply its own procedural rules, and the federal judge must copy that exact behavior.
Beautifully summarized. The federal judge is just a chameleon trying to perfectly blend in with the state court environment around it.
Mission accomplished. Listener, I want to sincerely congratulate you for making it through this deep dive.
Yeah.
We just covered the densest, most intimidating landscape in all of civil procedure.
It's a lot of material.
It is. We broke down the venue statutes, we explored the logic of the traveling suitcase, and we finally tamed the Eerie monster. When you understand that venue is about geographic fairness and Eerie is about preventing forum shopping, the MBE multiple choice questions stop looking like random traps. You now understand the map.
Absolutely. The law is not just a random collection of hurdles. It's a complex system designed to balance constitutional power, geographic fairness, and judicial efficiency.
Exactly.
But before we sign off, I want to leave you with a philosophical thought built upon everything we just discussed. In law school, we spend almost all of our time arguing about the facts of a case. We argue passionately about who breached the contract, who ran the red light, who was truly negligent.
Right, the drama of it all.
But looking deeply at venue, the traveling law trap, and the Eerie doctrine, is it possible that the procedural rules of the game actually dictate who wins and loses far more often than justice and facts do?
That is a staggering thought. The facts might not even matter if you were in the wrong building.
Think about the Ferens case we talked about earlier. The exact same combine harvester accident with the exact same facts and the exact same tragic injury was completely dead in Pennsylvania.
Because of the time limit.
Right. But by manipulating venue, traveling to Mississippi, and transferring back with a 6-year statute of limitations in his suitcase, Mr. Ferens won. Changing the physical building you stand in or manipulating which law travels with your file completely alters reality. It makes you wonder, is justice truly blind, or is justice just highly dependent on its zip code?
That is a lingering question for every future lawyer to ponder as they enter practice. The X-ray machine of the law might be murky, but you now have the tools to navigate it. Keep studying, keep focusing on the why behind the rules, and you're going to conquer the MBE. Thank you for joining us on this custom deep dive, and we will catch you next time.